Good afternoon, Your Honors. Wesley Clark for the appellant, Sallie Stevens, and I'd like to reserve 2 minutes of my time.
2 minutes?
Yes, sir.
Okay.
So, to begin with, I came into this case pretty late. I wasn't there at the trial court, and in fact, I didn't even write the appellate brief, but my client's former counsel became unable to practice law, and I've stepped in for the oral arguments, and I'd like to focus on fleshing out some additional legal theories that support the issue she's raised, and particularly what permeates this case in the trial court and the appellate briefing are the smuggling of two inappropriate and inapplicable legal standards into Tennessee jurisprudence. And first is the federal plausibility standard. It gets outright cited, quoted verbatim in the briefing below on the motion to dismiss, and the defendants attack my client's complaint based on its lack of plausibility in their briefing before this court. The plausibility standard from Iqbal and Twombly focuses on this distinction between conclusory allegations and legal conclusions, but really it's more about factual conclusions and what level of generality is too much and what is just enough, and it's a continuing source of pain for litigants in federal court, and that's why our court expressly declined to adopt it in Webb versus Nashville Area Habitat for Humanity. And that case is really instructive about why the trial court erroneously dismissed Ms. Stevens' complaint. Notice pleading, yeah, sure.
The court does note, though, that facts are still part of the pleading in Tennessee, not rejecting Twombly and Iqbal and the plausibility standard. I want to focus on the emotional distress aspect of
Sure.
the intentional infliction of emotional distress. As best I can tell, the facts that are pled here, plaintiff has suffered emotional harm, additional expenses for counseling, loss of parenting time with emotional harm bracketed, and continued anxiety about intended harm that could be brought upon her. Is that adequate factual pleading for an intentional infliction of emotional distress claim?
Thank you for asking that, because it brings up the second smuggled in defunct legal standard, and that's the erroneous, unable to bear it standard for serious emotional harm. That's, again, cited erroneously by both defendants, and it's been overruled since Rogers v. Louisville Land Company in 2012, our Supreme Court articulated the current governing standard for serious mental injury. So let's look at serious mental injury. There's a 6-factor non-exhaustive test that applies, which includes evidence of psychological manifestations of emotional distress, which is specifically inclusive of anxiety. Anxiety is pled. Additionally, another factor in this analysis is evidence that the plaintiff sought medical treatment, which, while relatively bare, there is an allegation that she received and sought additional counseling as a result of what happened here. And then, most importantly in this case, and probably why the defendants didn't cite this standard, is number 6. And that's, in certain instances, the extreme and outrageous character of the defendant's conduct is itself evidence of serious mental injury. And I would submit that fabricating evidence, instructing your nephew to plant drugs in your ex-wife's car, instructing your nephew to bribe a public official into pulling her over in order to frame her for an arrest, instructing your nephew to plant a GPS tracker on her car is so far across the line of outrageous that it shouldn't be tolerated in a civilized society, and it stands alone as evidence of serious mental harm under the Rogers v. Louisville standard.
With regard to the intrusion upon seclusion claim here, the privacy invasion
Yes.
tort, my understanding, there's a consent to the search here, right? And she says she was wrongfully stopped and because of this conspiracy that was afoot,
Right.
GPS device. If she consents to the search of the vehicle, can her intrusion upon seclusion claim survive consent to have her vehicle searched?
You're going right down my outline. So this is where I would take us back to Webb just for a moment to point out that a complaint may survive if it alleges sufficient grounds to sustain a recovery on any legal theory, even though it may not necessarily be the theory suggested. And I would submit that out of the 3 bases for intrusion upon seclusion suggested in the complaint, the public stop by law enforcement, but also the GPS locator and the planting of drugs under the car. The planting of drugs under the car and the GPS locator are independently necessarily sufficient to sustain a claim for intrusion upon seclusion. And why is that? Well, in Burnett v. Porter, this court said, that's 2011 Westlaw 4529612, this court said, look to Fourth Amendment jurisprudence for the determination of reasonable expectation of privacy. And that's what really the gravamen of this issue is here, is whether or not Ms. Stevens had a reasonable expectation of privacy in the underside of her passenger seat in her car, and whether she had a reasonable expectation of privacy against the GPS tracking. So then we go to 3 recent United States Supreme Court cases. U.S. v. Jones, 565 U.S. 400, stands for the proposition that the installation of a GPS tracking device on a vehicle was a search. Then we go to Carpenter, which came after Jones, and further reiterated that individuals have a reasonable expectation of privacy in the whole of their physical movements. And they compared the difference to someone sitting at the end of the road and watching you come and go. That's not something you have an expectation of privacy in. But the 24-hour-a-day, 7-day-a-week, constant surveillance of your present position is a protected privacy interest.
When we're talking about this in terms of a search involving reasonable expectation of privacy.
Yes.
And Jones, you can put together 5 opinions in Jones that say 28 days of surveillance would constitute a search under reasonable expectation of privacy. I'm leaving aside physical intrusion for the moment, but
right.
But the sort of my reasonable expectation of privacy violated 28 days. I think there's a footnote in Carpenter that may suggest 7 days. Right. This GPS device is 5 days, if I recall correctly. So, under established U.S. Supreme Court jurisprudence, do we have to travel the Jones physical intrusion route in order to find a privacy interference, or could there be a privacy-based claim based on 5 days of surveillance?
Jones explicitly left open the possibility. It wasn't raised in that case. The concurring opinions address this, but the trespass theory on which Jones traveled was not necessarily implicit or exclusive of a privacy violation based merely on an act of just gaining access to track a car. The trespass theory was an underpinning of Jones, but that same theory is addressed later on in Carpenter, and that's where we have the general recognition that an individual maintains that reasonable expectation of privacy and location data. And 5 days, 7 days, when we're talking about a reasonable expectation of privacy, why would 5 days be any less protected than 7?
Well, the Supreme Court didn't set, though, in Carpenter a sort of, and some surveillance may be permissible without constituting a reasonable, in violation of reasonable expectation of privacy. Do we know that 5 days is the point where we cross the line?
No, we don't know that 5 days is the point where we cross the line, but based on the standards articulated in those cases and their lineage, and specifically Byrd v. U.S. is another case where the possession of an automobile is something that necessarily entails a reasonable expectation of privacy, and that goes to the planting of drugs under the seat in Ms. Stevens' car. So if law enforcement would have to have probable cause or some other exception or a warrant to do what these private parties did to Ms. Stevens, then they violated a reasonable expectation of privacy. It's that simple. And they're going to say that, there's a reduced expectation of privacy in vehicles. True. However, there's not zero expectation of privacy. There remains a reasonable and significant in the Fourth Amendment context expectation of privacy, particularly in the underside of one's vehicle.
The restatement repeatedly references, in the context of intrusion upon seclusion, examples involving the home.
Yes.
And somebody peering into somebody's window, somebody entering somebody's home. Even the phone call example that's offered by the restatement is somebody at home being disturbed by a phone call. And can we take the intrusion of seclusion outside of the home?
Absolutely, because it doesn't have home written into the rule. It contemplates any place that a person possesses a reasonable expectation of privacy. And that's why courts look to the Fourth Amendment jurisprudence to flesh out where that reasonable expectation may lie, and it even applies in public places. There's abundant case law regarding the expectation of privacy one has in the context of an automobile, and all that is imported directly here to Ms. Stevens' claim. So that's both for the GPS tracker based on Jones and Carpenter and their progeny, and also on the specific invasion and planting of cocaine under the passenger seat of her car. And would we say that a law enforcement officer can walk into your car and stick their hands under your seat without a warrant? I think not. Beyond that, the conspiracy claim was kicked for failure to establish an underlying tort. I've gone through why I believe there's underlying torts that are valid, viable, recoverable here. But again, the Webb case specifically addressed two reasons why it declined to adopt the federal plausibility standard. And this is the asymmetry of information available to plaintiffs and defendants at the start of a case, particularly in conspiracy cases involving multiple defendants. That's exactly what Ms. Stevens' case is. This is a case about access to justice, access to the courts, and application of Webb, and the trial court is wrong.
Okay. I assume no one had any more questions.
Oh, I'm sorry. I saw my time was past 2 minutes.
That's all right. We were okay. Come on up.
May it please the court. My name is Terry Fan of the Rutherford County Bar, along with my co-counsel and son Chase Fan. We represent Mr. Bradley Allen and Venture Express. Mr. Ammett represents the co-defendant Charles Owens, so we've agreed to split our time 7.5 minutes each, with the court's permission.
Can we do half minutes?
Okay.
No, I didn't think so.
I'll take 7. I'll give Mr. Ammett 8 then.
Okay. Sorry, it's not that sophisticated a device.
All right. Is that fair? Or okay, then I'll just take 7. All right. If it pleases the court, I represent Mr. Bradley Allen and Venture Express. I would submit to your honors that these gentlemen have been sued in this case for $10 million in a hyper assumptions, wildly drawn conclusions of their involvement. I'll respond real quickly to what Appellant's counsel said regarding the access to justice and access to the courts. Well, I strongly disagree with that, because the appellant at this point in time when this occurred had access to the Chancery, it's the Chancery Court of Rutherford County, but a Williamson County judge was hearing it in the parenting case that had been going on for quite some time. She had the ability to go there to get discovery. She had the ability to go there to enforce any violation of the parenting plan, which may have been any disparagement or any type of interference with her custody that she alleged in this case. The other access that she had, that she uses in many of the allegations set forth in the 16-page, 65-paragraph complaint, is the TBI. She said, I cooperated with the TBI, with the Murfreesboro Police. I cooperated with them. The TBI did an investigation. In fact, the investigation was so thorough by the TBI that the defendant, who is not here with us now, Kevin Allen, is still in the case, and he was indicted, and Exhibit A to her complaint was the indictment against Kevin Allen. The TBI interviewed lots of witnesses. There is another reference in the complaint to a former officer, Jason Mathis, who talked to another person named Tim Oliver. They weren't sued. There was a lot of investigation I would submit to the court that the appellant did, which led to 0 facts against Venture Express and 0 facts against Bradley Allen.
Counsel, for purposes of notice pleading, though, and doesn't this complaint essentially say there's a conspiracy involving placement of a GPS device, there's cocaine that's been planted in the car, that the business enterprise was providing trips to local law enforcement, a former law enforcement officer, in return for if they would have stopped. Now, that may be all completely untrue, but for purposes of notice pleading, isn't that enough to state a claim of intentional infliction of emotional distress?
I don't think so, and here's why. those are conclusions, but there's not one bit of evidence that, there's not one allegation, there's not even an allegation that there was a payment made ever to law enforcement. They don't cite back in 2018 this was done, or even Mr. Owens in this case, or Mr. Kevin Allen in this case, when they were investigated by the TBI, said that there was a payment made. Mr. Owens, I think, there's an allegation that Mr. Owens made an allegation that somebody would pay for a trip, perhaps Venture Express or Mr. Bradley Allen, but there's no further allegation that, and that's I would submit to the court that is a leap, as there are other leaps in the complaint that suggest that Bradley Allen was the mastermind of this. Now, the appellant takes a lot of time in her complaint disparaging Mr. Allen and talking about he gives to political campaigns and he's on boards and things like that, but there is I would submit it's meritless as to make that, or it's such a leap to make that jump. So generally, when a Rule 12 motion is filed, I would suggest to the court, the immediate cure is to file an amended complaint. In this case, the appellant chose not to file an amended complaint, and with the filing of our motion, it was obvious where we were. With the access that she apparently had to the TBI, to the district attorney who did the indictment, to statements made by that person under investigation by the TBI, Kevin Allen, if there was something I would suggest to the court to flesh that out, we would have seen it, which would have withstood the muster. I would submit to the court that those bare allegations they're too far-fetched.
Let's talk about it. So one of your contentions, your brief, is that outrageousness hasn't been shown here. And so intentional infliction for emotional distress, I mean, would somebody say it was outrageous? And can we really say as a matter of law that a conspiracy involving an ex-husband, family members, a business enterprise, law enforcement to track somebody, plant drugs, call the police, have them pulled over, have them found with drugs is not outrageous as a matter of law?
It's a narrow gate. As the Tennessee courts have said for many, many years, it's a narrow gate to get through. And here's the other idea with that, I guess. It was a failed attempt. She didn't get arrested. She didn't get frisked. She didn't get detained. She said there was a very astute young officer, or I shouldn't say young, a very astute patrol officer who stopped her and said, she didn't get a citation. She agreed to search the car. There's an allegation that it's cocaine. Is it cocaine? There was not a report. I don't know that there was ever any proof of that or substance of that in the complaint, but there's the allegation.
So it didn't work. Does that mean it wasn't an outrageous?
It was if it was an attempt, and obviously the complaint alleges it was an attempt by Kevin Allen, and it was a failed attempt for which she had no harm. I would submit to you. She didn't have to post a bond. She didn't hire a lawyer. She wasn't.
So there's no. So assuming that the complaint is true, and that something looking like cocaine was planted in her car, and a GPS was attached to her car, and she was pulled over and subject to search, and there's no damages for that. That's just like, oh, no big deal. I just about went to jail for possession of cocaine and probably lost my kids, but no harm, no foul?
Well, none of those things happened. She didn't go to jail. She didn't lose her child. There was no use of these allegations that affected.
That probably goes to the extent of her damages, maybe, but not to whether she actually had any. I mean, I'm having a hard time buying that if someone went through this, they would it'd be fine. They wouldn't have any damages in any way. Like they wouldn't have any anxiety or emotional distress.
Well, I guess, and I'm about to run out of time, and I understand the point that the court is making, but all of those are directed to the remaining defendant who the circuit judge left in, Kevin Allen, not to this extreme jump that Brad Allen and his employer had anything to do with this idea, this plan that was carried out by Kevin Allen. I understand my time has expired. We'd ask the court to affirm the trial court's ruling as to my two clients.
Thank you.
Good afternoon, Your Honors. Stephen Emmett, member of the Rutherford County Bar, represent the appellee Charles Owens. My client and I appreciate the opportunity to appear in person here today. Given the somewhat limited time I have to respond to these arguments, I do just want to focus on my client, Charles Owens, and as the allegations relate to him in this appeal. I'm going to try not to go over everything that Mr. Fan went over, but I would like to point out, I think this is kind of critical. We do have a new attorney, and I don't believe it's Mr. Clark's fault necessarily, but there was no reply that was filed. There's not anything in writing that Mr. Clark has filed, and so some of these arguments kind of hearing for the first time, and I would have to respond off the top of my head or just sitting here. And I wanted to point out as well in the brief that was filed, the initial brief that was filed by the former attorney for the appellant, she didn't cite the transcript of evidence at all. I understand that this is a Rule 12 motion to dismiss and that the review by this court is de novo, but she didn't give this court any kind of citation to that hearing, which lasted, I think, a couple of hours to show how the trial court improperly analyzed the Rule 12 motion. I think that's critical because it doesn't show exactly how she thinks the issues presented on appeal were error. That's her first issue, is that the trial court erred, and she failed to show that. And I think it's just worth pointing out, and I made mention of that in my brief. Second, I'd like to briefly discuss these torts. I know they've already been discussed, and I've heard the back and forth on that. I do think, and the question from Your Honor a moment ago about just letting this go, well, I just get pulled over and it's no big deal. I think she has to rely on her underlying torts. Her underlying torts, and Your Honor hit on it a minute ago, for intentional infliction of emotional distress, assuming arguendo that this is outrageous, and I might stipulate that for purposes of the argument, but assuming that it's outrageous, she has to plead the third element of IIED, and that's serious mental injury. That is a past serious mental injury. Her attorney conceded at the argument, the oral argument for the motions to dismiss, that the plaintiff had not received any mental health treatment. Now, if this case goes to trial, and I understand this is getting into damages, she's going to have to hire a Rule 26 expert to evaluate her for the first time to say that she had a past serious mental injury. The cases that this court has ruled on and the examples that are found are the really obvious ones. The one that everybody remembers is the child and the formaldehyde that was shown to the mother. That's obviously something nobody gets over. I would submit to this court that this, even if this is outrageous, that she can't satisfy that third burden, because she doesn't allege that she had any serious past mental injury.
Counsel, she does state in her damage claim, plaintiff has suffered emotional harm, extraordinary legal expenses, additional expenses for counseling, loss of parenting time, emotional harm, and continued anxiety about the intended harm that could be brought upon her. Now, you're saying at the hearing there was a admission there was no additional counseling time. Are we converting or is the trial court here converted a motion to dismiss to a motion to summary judgment?
No, Your Honor, and I apologize if I'm confusing you. What I essentially am saying is that she failed to plead facts about the elements for intentional infliction of emotional distress. I understand she said emotional harm, but this is a serious mental injury, and I think the court could go back to the case that I cited here in my brief, Arnett versus Domino's. This court has clarified that recovery for intentional infliction of emotional distress is limited to mental injury, which is, quote, so severe that no reasonable person would be expected to endure it. And I just don't think that, you can't say that this is on the same level as something where somebody's invading into somebody's home, or they're taking pictures of them and show them to their buddies when they're getting pictures developed. This is not a situation where you could infer, or the court could imply, that a serious mental injury occurred. She didn't plead serious mental injury, and she stipulated to the court she's not had any mental health treatment. And one other point on that, I would say that, most of these cases, there is an allegation of nightmares or that they're scared, humiliated. None of that was in there, and I understand what the court's pointing out. Those allegations, I think, are bare. For the claim of invasion of privacy by unreasonable intrusion and seclusion, and I don't have a lot of time here, but I want to say that I think the most important thing on this invasion of privacy is that all the allegations surround Kevin Allen. Kevin Allen was the one that ordered, paid for, received, and planted the GPS tracking device.
But counsel, doesn't she assert that Mr. Owens was involved in a conspiracy, that he was the key figure in calling up the police and getting her car stopped and making sure they knew where he was at and isn't he the linchpin in terms of making sure that she stopped? According to your allegations, again, we're just here at the pleading stage, so it may be completely untrue, but isn't she making that assertion with regard to his actions here?
So the basis for the motion to dismiss, and I would give a long way of answering your question, I apologize, but I base the motion to dismiss on Tennessee Supreme Court's definition for a civil conspiracy is that a combination of two or more persons, each having the intent and knowledge of the other's intent. There's no allegation that Charles Owens knew what Kevin Allen did. The allegations are that he called in basically a concerned citizen, stopped, somebody's transporting cocaine. That's all the allegations are. I would submit that that's not fair to drag him into this lawsuit when here we have, he was investigated. Charles Owens spoke to the TBI, I believe. He was not indicted. The only person that was indicted was Kevin Allen.
It's a very different evidentiary standard, though, from how we're looking at this at the pleading stage.
I understand that, Your Honor. I just, it's just a hunch, I suppose, is what the plaintiff is saying. I don't believe that's fair to my client when, the allegations are all about Kevin Allen. And
doesn't that return to opposing counsel's argument that what's really happening here is that we've got a Twombly and Iqbal plausibility reading that's coming in, that these allegations seem far-fetched, implausible, thin, and this complaint is not going to be offered, I think, probably as a model for a complaint anytime soon, and that there's a reading in that it just looks too implausible, so dismiss it, that looks like Twombly and Iqbal rather than Tennessee's notice pleading standard, very liberal notice pleading standard.
And again, I would go back to, this is something I'm just responding to off my feet here because this is the first time I've heard it. To the extent the court would like it to be briefed, I'd be glad to, if I could do that, I'd be glad to give an opportunity. But I think that if the evidence is not there and the facts are not there, then the case should be dismissed. I understand this is not an evidentiary-based motion, but she didn't plead it, and I think she's bound by her pleadings. She didn't plead serious mental injury, and I would submit that this intrusion into privacy, the intrusion into privacy part was committed by Kevin Allen, and the allegations as to my client, Mr. Owens, are not that he invaded into her privacy, but essentially that he called in a stop on the vehicle. I would submit that she's on a public road. He doesn't know what Kevin Allen did, and the allegations don't even say that. And finally, I'm running out of time, Your Honors. She also appealed the trial court awarding the attorney's fees. I would submit that the attorney's fees were reasonable. The appellant claimed that it was not a final appealable order, but the order specifically said it was pursuant to Rule 54.02, which is a rule that allows for one defendant to have a final appealable order when other defendants remain in the case. Be glad to answer any other questions the court may have.
No questions.
All right, thank you, Your Honors. Appreciate it.
Mr. Clark.
First, I would just like to point out that the erroneous legal standard from Arnett, the unable to bear it standard, was just reiterated here again. So aside from that, please allow me to answer any questions that any of you may have, and I hastily failed to do so in preserving my time earlier.
No questions.
Okay, all right. Well, so one other issue I would like to address is the conspiracy claim and how it's not necessary for the ultimate objective of impairing Ms. Stevens' custody to be achieved in order for these lesser goals of the conspiracy to have been achieved and cause Ms. Stevens harm, namely causing her vehicle to be stopped by law enforcement by use of an illegally planted GPS device in order to discover cocaine planted there as an object of the conspiracy by these defendants. Now, those are all pled. Those are all intentional acts that resulted in harm to Ms. Stevens. And again, just because her body wasn't put into jail or her parent time wasn't parenting time wasn't taken away, doesn't mean that she experienced no emotional damages. I mean, what would I feel like if an officer pulls me over, discovers a GPS in the back of my car, and pulls a bag of cocaine out from under my passenger seat? I'm going to be pretty shook up about what might happen to me. And that's the definition of the medical condition anxiety. It's fear. It's fear based on the future. It's fear based on what these defendants instilled in Miss Stevens. And that was the purpose, and that's an element of serious mental injury. So the outrageous nature of the conduct, anxiety, counseling, under the applicable standard from Rogers, she's alleged serious mental injury, and she's alleged invasion of privacy, she's alleged conspiracy. And again, notice, they're on notice about what this lawsuit is about. That's what we had to prove. Ms. Stevens has done so, even though it's definitely not an example of model pleading. Anything else?
Thank you.
Thank you.
Thanks to all of you. Would you please recess court, please?
All rise.